not forget what you want to, your questions. Thank you so much. Barrister David, please, the floor is yours.
Thank you, Dr. Dorothy, for the wonderful introduction. So, the objectives of the workshop today would be to understand how refugee claims are made and processed in Canada. We'll learn how the evidence, credibility, and preparation determine your success. We're also going to examine how Bill C-2, the Strong Borders Act, and Bill C-12, the Strengthening Canada's Immigration System and Border Act, could restrict access to refugee protection in Canada. And then participants will also recognize the role of procedural fairness and advocacy in safeguarding refugee rights. So, good evening, everyone, and welcome to the workshop today titled Refugee Claims in Canada, an in-depth guide. I'm David Ibeawuchi, Principal Counsel at Fission Law Professional Corporation. I'm pleased again to partner with NELO Immigrant Community Services to continue our community legal education series. So this evening, we are going to unpack how refugee claims are made and what the evidence matters. We'll focus on getting it right at the RPD stage. So, understanding the refugee protection system in Canada, it requires awareness of the current legislative climate and legislative trends and how the new proposals before the parliament could reshape or even erode the long-lasting rights that refugee claimants have in Canada. So there are two bills currently at the parliament in Canada, Bill C-2, the Strong Borders Act, and Bill C-12, Strengthening Canada's Immigration System and Border Act. So this parliament, the 45th parliament, began on 26th of May 2025, and these bills were introduced. The first bill, Bill C-2, was introduced on 3rd of June 2025 and is currently at the second reading at the House of Commons. The second bill, Bill C-12, Strengthening Canada's Immigration System and Border Act, was introduced on 8th of October 2025. It's currently in the committee stage after it went through the second reading on October 23rd, 2025. And the sponsor for these bills are the Honorable Minister of Justice and Attorney General of Canada. So I'll talk briefly about the bills. The Bill C-2, according to the sponsor of the bill, the purpose of the bill is to enhance border security and protect the integrity of the asylum system in Canada. So the key provisions and the ineligibility measures that are introduced in the bill includes the 1 year limit rule. So what this means is that an asylum claim which is filed more than 1 year after an individual arrives in Canada after June 24th, 2020, will become ineligible for referral to the Immigration and Refugee Board. So the Immigration and Refugee Board, the IRB, is the largest independent tribunal in Canada, and this tribunal is responsible for hearing and determining refugee claims that are made in Canada. So asylum claims that are filed more than 1 year after an individual arrives in Canada will not be referred to the Refugee Board according to this new legislation. So under this bill, refugees who do not file a claim within 1 year of their first entry to Canada, they are denied access to a full hearing before the Immigration and Refugee Board. This 1 year bar, it severely disadvantages many deserving asylum seekers and potentially puts them at risk of persecution. So it's not unusual, especially for countries, to experience dramatic changes in conditions and circumstances. And persons from those countries, for example, individuals who are in Canada on work permits or study permits, they will therefore find themselves in need of refugee protection for some reasons that are not fault of theirs. So, based on the current provisions of this Bill C-2 and Bill C-12, the 1 year bar would apply to individuals who have visited Canada even in the past, and even if it's for a few days, and even if they were children as at the time they visited, and then they will not be allowed to make refugee claims. So the bar will divert claimants to the pre-removal risk assessment process, the PRA. So the PRA process is another process that is ongoing in the system. Before individuals get to the stage of PRA, if individuals make refugee claim, you'll be entitled to a hearing at the Refugee Protection Division. If the hearing is not successful, you will go for an appeal at the Refugee Appeal Division, and if the appeal is not successful, the individual can apply to the federal courts for judicial review, and then the PRA remains the last bulwark for individuals seeking protection. However, if this bill is introduced and it passes the second reading, third reading, and is enacted into law in Canada, individuals who make claim after 1 year of residing in Canada will be moved directly to the last stage, which is the pre-removal risk assessment stage. So this bar will divert claimants to this process, and it's mostly expensive. And apart from the financial costs, a lot of civil society organizations have kicked against the bill because the preparation time that individuals will require to prepare and advance a good case at the pre-removal risk assessment, the chances individuals have are limited. And where prior applications are refused, which of course the refusal rates for pre-removal risk assessments are very high, where such applications are refused, it will lead to overburdening the judicial system. The individuals will rush to the federal courts and file application for leave and judicial review of the refusal of the prior application. And the prior applicants do not benefit from automatic stay of removal. Unlike the refugee claim process, where you make a refugee claim, you're given the benefit of a stay of removal until a decision is made. And in the event of the decision being negative, an individual can apply to the appeal division. The individual still has the benefit of a stay of removal, as well as even up to the federal court. But when the claims are diverted to the pre-removal risk assessment, there is no stay of removal for you to stay back in Canada and await the outcome of any application for leave and judicial review. You must file an application to stay your removal from Canada. So the operational impacts of this new legislation would seem to impose strict observance, and it will strain the legal operations and delays of individuals who are seeking protection to return counsel to properly file their application. So the second rule, based on the bills C2 and C12, would be the 14-day border rule. So refugee claims made by individuals who enter Canada from the United States, between the lands of the ports of entry, the land borders, and you do not claim protection within 14 days, you will also be ineligible for referral to the Immigration and Refugee Board. So people who cross irregularly, for example, the border at Roxham Road at the Quebec border, and you take more than 2 weeks to find counsel, and or maybe you're seeking safety, or you're still traumatized by the events that made you seek for protection, you could automatically lose your right to a hearing before the RPD, based on the new legislation at the parliament. So, like I said earlier, the pre-removal risk assessment, the PRA, is a substitute. So, those affected by the ineligibility rules may still apply for a pre-removal risk assessment to ensure you are not returned to a country where you face a risk of persecution, torture, or death. So, PRA is not equivalent to a full refugee hearing, because PRA, the pre-removal risk assessment, is a paper-based application by an immigration officer. It's not by a tribunal, and it's also not a hearing. It's not mandatory in situations where claims are referred to the pre-removal risk assessment. So this substitution to PRA, as opposed to the IRB, raises concerns about fairness, independence, and evidentiary rights. So it's important to note that the PRA process is an inadequate process for individuals who are seeking protection in Canada, because, like I said before, it does not guarantee access to an oral hearing, as the Supreme Court of Canada has decided in several cases, and it does not offer the procedural protections granted at the IRB, including the right of appeal. So, PRA decision makers are usually IRCC officials and they don't have independence like the Immigration and Refugee Board. They don't have the expert resources to assess the merits of a refugee claim. And consequently, the federal court will face additional backlogs as there will be increased litigation to contest prior refusals. And many of the individuals in this category will be stuck in legal limbo because some of them come from moratorium countries. Moratorium countries are countries which Canada has suspended removals as a result of the generalized insecurity. For example, we have Haiti, Afghanistan, and Venezuela. So since PRRA is only triggered when Canada is ready to remove an individual, they will have no way to have their refugee claim heard, and they will remain in Canada without status. So this will put thousands of people in a long-term precarious position. So a lot of civil society organizations, the Canadian Bar Association, Canadian Association, Immigration Association for the lawyers, and a lot of the organizations have presented petitions and proposals before the parliament to refuse to enact this law because the law has introduced sweeping changes. Part 8 of the Bill C-2 and Bill C-12 has expanded the executive powers. For example, Bill C-12 it gives the government powers to cancel, suspend, and change a whole range of immigration documents if it is deemed to be in public interest. It's important to know that the term public interest is not defined by the legislation. So these documents that will be cancelled would include permanent or temporary resident visas, work permits, study permits, travel authorizations. And the cancellation and suspension of these documents will lead to more people living without status or in extremely precarious conditions, negatively impacting their rights to access employment, education, and social services. So the expanded powers that the governments are trying to introduce by this bill will authorize the cabinet to issue public interest orders. And in practice, the cabinet will have the power to invalidate lawful status and documents in mass without opportunity for the individuals to follow due process, without the government following the due process uh, in enforcing all these laws. So the concerns of the critics are so numerous. I don't think we can talk about all the concerns, but we'll just talk about the key points. So the power to suspend rights of large categories of migrants under the banner of public interest is a violation of the rule of law and procedural fairness. So Bill C-12 allowing the government to suspend the right to make new applications in a specific category and also to suspend and terminate processing of applications already submitted, including applications for permanent residence or temporary residence or for work and study permits, if it is deemed to be in the public interest, it is a violation of the rule of law and procedural fairness. So it's important for individuals to note the changes in the legislation and the efforts that are being made to forestall the law from being being passed by the parliament. So some of the draconian provisions that are being introduced by this bill also includes declaring refugee claims as abandoned even before the claim has been referred to the Immigration and Refugee Board. So under the proposed amendments, for example, if a claimant does not provide the required information and the documents in a timely manner, or a refugee claimant fails to appear for an eligibility interview, the claim will be sent to the IRB to decide whether to declare it abandoned. So this fails to consider that sometimes people face frequent communication and technological barriers, and some individuals lack support in complying with the requirements, and some might need simply just a few days to provide the documents, or they'll face the exceptional circumstances. Sometimes illness can contribute. So the automatic nature of the provision in the Bill C-12 will generate a new backlog of abandoned claims and abandonment hearings for the IRB. So this provision has a negative impact on vulnerable claimants, such as claimants who have mental and physical health issues and including unaccompanied minors. So once a claim has been declared abandoned, individuals cannot make another refugee claim. They lose their rights to federal healthcare coverage, and they also face a 12-month bar on pre-removal risk assessment. So it's important to analyze the constitutional implications too, because Section 7 of the Charter of Rights. Please, can you mute? I can hear some background noises. Please, can you mute the individual who is speaking? Can you make me a co-host to the meeting? Okay, yeah. Okay, so like I was talking about the constitutional implications, Section 7 of the Charter of Rights in Canada, it protects against the deprivation of life, liberty, and the security of a person unless it is done in accordance with the principles of fundamental justice, which means that the laws must not be arbitrary and the laws must not be overbroad, grossly disproportionate. And then, under this lens, based on Section 7 of the Charter of Rights, the bills, Bill C-2 and Bill C-12, the ineligibility provisions, it risk being arbitrary because denying a hearing to people who are already inside Canada does not meaningfully enhance the border integrity as the bill is proposed in the parliament to enhance the border integrity. Also, the law is an overbroad law because it captures long-term residents and students who develop genuine fear of persecution years later after they have entered Canada. So legal experts have predicted constitutional challenges if this law is enacted. And then, like I said, for example, Canadian Council of Refugees and Amnesty International, they have all stated that these bills will severely undermine the access to justice for asylum seekers, and it will create systemic barriers for vulnerable groups, particularly women, LGBT claimants, and survivors of violence. So, service providers like Legal Aid Ontario and some other social service providers have warned that the timelines would also make it nearly impossible for people in this position to secure representation. So, procedural fairness is a constitutional guarantee under Section 7 of the Charter, and any legislation limiting access to hearings will likely face legal challenges. So, at the introduction of this bill in the Parliament, the government uh, brought witnesses, and including the witnesses included the Minister of Immigration, Refugees and Citizenship Canada. The minister could not explain to the Parliament why they are introducing bills that will make people to rush to the federal courts. So these are some of the issues and some of the concerns that have been raised because the government is trying to stop a process and then overburden another process, which is against the rule of law in Canada. So when the 45th Parliament went on recess after they resumed on the 20th of June, they went on summer break and then they came back. They returned on September 15th, and then they introduced Bill C-12 on October 8th with exactly the same provisions in Bill C-2. They introduced them in Bill C-12, strengthening Canada's Immigration and Borders Act. So the same ineligibility clauses from Bill C-2, expanding surveillance and data sharing between Canada and US, and returning the power of cabinets to cancel documents in mass, those are the provisions that were still retained. They still push them back into the new bill. So Bill C-2 and Bill C-12 does not offer the kind of protection that Canada needs as a democratic society. So civil society organizations, like I said, have urged the parliament to withdraw both bills because it has violated both Section 7 of the Charter and the 1951 Refugee Convention, which was domesticated in Canadian law, Section 96 and 97 of the Immigration and Refugee Protection Act. So the combined impacts of these bills on refugee rights include denial of access to hearings. A refugee claimant cannot be denied hearing. If you make a claim based on the law as it is, you will not be denied a refugee hearing. However, you will not be denied refugee protection. However, you will be diverted to a pre-removal risk assessment, which is the end road for many people who make refugee claims that failed. And then it has eroded the procedural fairness in the fact that individuals cannot have the opportunity to have their case heard. The expansion of the powers of the parliament and the cabinet ministers to void certain immigration documents in mass is also a devastating effect on the rights of refugee claimants. So these measures collectively they shift the refugee system in Canada from an adjudication process to administration, prioritizing control over compassion. So I'm going to leave this for discussion. We'll take some questions at this point before we go into the main topic for refugee um, claims in Canada. So I don't know if so far individuals have any questions that they want to ask based on Bill C-2 and Bill C-12, which I've talked about before we go to the next.
Please, I don't know if anyone has question or clarification on this bill. Hearing about this bill, bills, is it Bill 2 and the C-12 is mind blowing. Someone who is a refugee and who have not gotten his or her status, I think. Anyway, let me hear from the participant first before I make my own submission. Thank you so much. Thank you so much, Barrister David.
You're welcome.
Please, you can put your question on the chat or raise up your hand, unmute yourself and ask your questions, please. Okay, Mohammed Arifo Rahman. Okay, thank you.
Yes, thank you for giving me the floor. The question. So my question is that so the both bills have same sort of provisions.
Okay, continue, please. Sorry.
So I saw that both will have mostly same sort of provisions. Just because of it will be tough for the parliament to pass Bill C-2, and this is the reason they are trying to, in an emergency basis, just to tackle the situation. They are introducing Bill C-12, and they are planning to pass it earlier provision, because if they pass Bill C-12, I don't think that they also need to pass Bill C-2. It will be like as a backup plan. They kept it like if they fail to pass Bill C-2, C-12, the faster provision to take the initiative because of the mess has been done in the immigration.
Yes. Bill C-2 and C-12 mirror exactly the same provisions. So what they cannot achieve in Bill C-2, they're trying to achieve in Bill C-12. That's exactly the position.
And you still think that eventually if they pass the bill C-12, and due to the, as you mentioned, that law is going to violate the Charter Section 7 and is going to the law is going to overboard. So under that basis, if it is going to face the constitutional challenge on that moment, if the law is going to challenge in a basis of constitution, what will happen during that time is the bill will be until they set aside the constitutional challenge, the bill will be active, or how it will be generally.
So the moment a bill receives royal assent, that is the final stage. The bill becomes active. It becomes a law until it has been set aside by a court of a competent jurisdiction.
So during the set aside process,
yes,
still the bill will be active until the bill is set aside. If the bill is set aside, then it will be a different issue. But even if it is challenged, so the challenge will be in court procedure, but still the bill will be in an active status, right?
Yes, it will be active status because it will be law as at the time it will be passed.
Okay, thank you. Thank you.
You're welcome.
Okay, so here, a question on the chat. is it true that these two bills, if passed, have retroactive effects?
Yes, so that's a very important question because the provisions, the transitional provisions of the bill make it clear that the bill will take effect from the date Bill C-2 was introduced to the Parliament. And when was Bill C-2 introduced to the Parliament? Bill C-2 was introduced to the Parliament on 3rd of June 2025. So if the bill is passed in the current form it is, then definitely it will be retroactive until the 3rd of June 2025. So it's also important to note that before the bill is passed, because of a lot of individuals have raised concerns, lawyers, civil society groups, and even some government departments, for example, Legal Aid Ontario. Legal Aid Ontario is funded by the Department of Justice. They submitted a memorandum to the House of Commons Committee, and they also made their recommendations that passing this law will also impact on the ability of legal aid to provide functional services. So, as a result of the pressure and the nature of the law itself, I do not think the law will pass in its current form. If the law will be passed, some provisions will be amended to reflect whatever aims that the government will seek to achieve. So, because the law is presently situated as it is right now, does not mean that this will be the final bill, the final law that will come into effect. So the parliament will still amend and they will still take into consideration the opposition and the memorandum, the submissions that have been made by interested parties before it finally becomes a law, if it will see the light of the day.
I have a very small question. Can I ask?
Yes, please, go ahead.
So the question is regarding the retrospective effect of the law, like as you clearly mentioned about that sort of thing. So I saw that a lot of people, like just because of the June 3rd provision, like the Beetle C-2 was introduced on that day, people know that one. And still, like, people are making claim in this stage. So, and they are getting the brown paper, work permit, a lot of things. So what will happen, this kind of people, the people, those who are applying or those who are already applied after June until now, because the bill is still in a position of bill, not in a law. So if during the transitional period of 4 months or 5 months, the people of those who are applying and getting their paper, staying in Canada more than 1 year, 2 years. So how, like, when they already have a status, like, they are not making application after the bill active. So what will be happen that sort of people if the bill gets retrospective effect?
So during the committee meetings that the House of Commons, they were trying to have a committee meetings, and the Minister of Immigration was asked exactly this question: are you sending everybody to the federal courts? Because the federal courts issued a notice a few months ago that they have become overburdened. The number of cases that have been filed in the federal court within the last year doubled the number of cases that the federal court has ever had in its inventory. So any attempt at this point to overburden the courts, I'm sure that they are going to vehemently oppose any attempt at that. Because in the situation where claims have been referred to the refugee board and the individuals have been issued refugee protection claimant document, they have their brown paper and they have their work permits, and then you now make them ineligible again. So the claims are already before the refugee board, they have the RPD file numbers, and in most cases, if the claims are filed, they must have been assigned a board member. So at that point, it will be difficult to remove that case and make those people ineligible, because every individual that will be made ineligible will definitely file a challenge in the federal courts, and then the federal court will receive thousands of litigation based on that singular provision, because they want to make the law retroactive. So they are taking into consideration all this at the parliament, and I'm sure that at the end of the deliberations, we are going to see what the outcome will be. We'll further answer and watch what the outcome will be.
I 100% agree. 100%. It is also in my mind that it will be very tough. Like roughly 10 to 20,000 application will be filed if they take that sort of decision. So yeah, thank you for your answer.
Yes, welcome.
Thank you, Mohammed. There's a question in the chat before we go to Catherine. It says, if the bill is passed, will it take to get PR status from terrorism?
So PR status has nothing to do with the bill. The IRCC department, they are responsible for increasing the processing time or reducing the processing time. And as we have seen over the period of time, the processing time is not fixed. Sometimes they increase processing time, sometimes they decrease it. So that's an administrative procedure. But if the bill is passed, IRCC has the power to stop accepting new applications. They can decide, based on the broad executive powers that will be given to them by the bill, they can decide to stop accepting new applications for permanent residence or temporary residence, which is not also a good thing. So these are the things that people are fighting against, civil society organizations. Because where someone has a right to remain in Canada as a protected person who has been granted refugee status, then on what basis would you ask that individual not to apply for permanent residence? So there is going to be a lot of legal challenges and the situation will be messy. So I hope so. I hope it doesn't get to that point.
I hope so too. So Catherine, please, can you ask your question?
Okay, thank you, Nero Immigrants. Thank you very much, David, for the very insightful lecture. But I just wanted to make a contribution to Mohammed's question on the issue of retroactive nature of the bill. And I'm not sure, and that's why I'm coming to you, David. If there is any provision in this bill, both Bill C-2 and Bill C-12, that are stated that it's going to have a retroactive nature if passed, I'm not sure. I think that is still I don't know, and I need clarity if there is any provision that states that, because I know that it's after this bill has been passed that we know whether it's going to have a retroactive and or it's going to be from the day it was passed. Then the second thing that I also want to mention is the fact that the parliament themselves and Canada, they understand the nature of refugee process. And I'm not sure they won't be so mindful of earlier applications that have been handled and earlier permit that has been granted for them to make it retroactive. So in understanding your presentation, I'm thinking to myself that would they really just want to make this retroactive, or is going to be as going forward once the bills are passed? So I just want that clarity from you, if there is any provision in the bill, because that's not clear to me. Thank you.
Okay, thank you very much. So when the bill was presented, the transitional provisions in the bill did not specifically mention the word retroactive, but in the transitional provisions, it was clearly indicated that this bill will apply to individuals who make refugee claims after June 3rd, 2025, when Bill C-2 was introduced to the parliament. So that's, in the real sense of it, that's a retroactive application of the law, which is also what individuals and civil society organizations are kicking against. A law cannot be made retroactive. For a law to be valid, the law must take effect from when the law is enacted. So it's in the law. If you check the full text of the bill, you will see where it is written, the transitional provisions, the effective dates of the bill.
Thank you so much.
Thank you.
That answers your question, Catherine. So Olusola is saying that there is a lot of rumors as to retroactive. I hope they clarify this retroactive issue.
Yes, I think we've clarified it.
Yeah, I hope they will. To my own understanding, since the bill has not been passed, I think it's a wake-up call, for both immigrants and refugees. I think the society in general. Any other question, please? Do we have any other question or clarification? Okay, there's another question. insightful. Thank you, Chukwemeka.
Okay, at this point, we can take a break for 9 minutes. We'll reconvene by 6 p.m. Toronto Eastern Time, and then we continue the second part of the workshop, which we'll be talking about making a refugee claim in Canada.
Thank you so much. So just have a